Hey, you're about to hear Zach read the concurring and dissenting opinions in RV Marakah. There's no chit-chat for this one, just me. But if you want to hear the majority opinion and our chit-chat on the case, head on over to episode 6, which will give you part 1 of this decision. Enjoy!
The concurring judgment was delivered by Justice Rowe. Section 8 of the Canadian Charter of Rights and Freedoms provides that everyone has the right to be secure against unreasonable search or seizure. To ground a claim under Section 8, individuals must establish that they have a reasonable expectation of privacy in the subject matter being searched. Once that expectation is established, the individual claimant gains standing, which allows them to challenge the lawfulness of a search or seizure and to ask to exclude unlawfully obtained evidence under Section 24(2) of the Charter. As noted by the Chief Justice, however, standing is merely the opportunity to argue one's case. It does not follow that the claimant's argument will succeed or that the search will be found to violate Section 8. The existence of a reasonable expectation of privacy depends on the totality of the circumstances, with reference to 4 factors: subject matter of the search, the claimant's interest in the subject matter at stake, the claimant's subjective expectation of privacy in the subject matter, and the objective reasonableness of that expectation. See the Queen and Spencer, the Queen and Cole, the Queen and Patrick. This final factor, the objective reasonableness of the expectation, is assessed by a number of considerations that vary according to the circumstances in each case. In this case, both the Chief Justice and Justice Moldaver assess the objective reasonableness of the expectation of privacy of the appellant, Mr. Marakah, on the basis of 3 considerations: the place of the search, the private nature of the subject matter, and control over the subject matter. The crux of their disagreement is the importance of the control in this analysis. The Chief Justice takes the view that Mr. Marakah and his accomplice, Mr. Winchester, shared control over their electronic conversation, and that this is only one factor to be considered in the totality of the circumstances. Justice Moldaver, by contrast, considers control to be the decisive variable of the analysis on the basis that, when it comes to the reasonableness of a person's expectation of privacy in a communication, including text message conversations, control is a crucial contextual factor. He reasons that by virtue of Mr. Marakah having no control over his message, his expectation of privacy was not objectively reasonable. The technological means by which we communicate continue to change. An approach based on the totality of circumstances responds to such change because the broad and general right to be secure from unreasonable search and seizure guaranteed by Section 8 is meant to keep pace with technological development. See the Queen and Wong. Digital communication inherently limits the control we have over the messages we send. It inevitably creates a record that is beyond our control. While the same may be true of letters, for example, courts should analogize with care when comparing such different modes of communication. As this court held in the Queen and Vu, the privacy interests implicated by computer searches are markedly different than those at stake in searches of receptacles such as cupboards and filing cabinets. Computers potentially give police access to vast amounts of information that users cannot control, that they may not even be aware of, or may have chosen to discard, and which may not be, in any meaningful sense, located in the place of the search. Similar considerations apply for the search of text messages. The quantity of information they contain and the speed at which they are transmitted give text messages a conversational quality that differs markedly from letters. For this reason, text messages are akin to a digital conversation. The modalities of texting inherently limited Mr. Marakah in his capacity to exercise control over the record of his conversation with Mr. Winchester. This alone should not be fatal to his reasonable expectation of privacy. The general approach set out by the Chief Justice with respect to the existence of a reasonable expectation of privacy accords with the jurisprudence of this court. Applying that approach to the facts of this case, I would agree that Mr. Marakah has standing. That being said, I share the concerns raised by Justice Moldaver as to the consequences of this decision on standing. If the sender has a reasonable expectation of privacy and the record of his digital conversations, what happens when the recipient wants to show that record to the police? Are we opening the door to challenges by senders of text messages to the voluntary disclosure of those messages by the recipients? As Justice Moldaver suggests, this would lead to the perverse result where the voluntary disclosure of text messages received by a complainant could be challenged by a sender who is alleged to have abused the complainant. Furthermore, what Justice Moldaver refers to as a large project prosecutions, often with multiple accused allegedly involved in organized crimes, would become more complex and might collapse under their own weight if each accused gained standing to challenge the admissibility of messages received by any other person involved in the alleged offense. I see no way within the confines of this case to deal with these concerns, as they do not arise here on these facts. I would say only that the principle and practicality must not be strangers in the application of Section 8, where he might thwart justice in the course of seeking to achieve it. In the end, I concur with the Chief Justice. Writing for the dissent, Justice Moldaver. 1. Overview. Section 8 of the Canadian Charter of Rights and Freedoms guarantees everyone the right to be secure against unreasonable search or seizure. The protection guaranteed by Section 8 strikes a balance between the privacy rights of individuals and the public interest in law enforcement. In this appeal, the court is called upon to consider that balance as it applies to text message conversation stored on personal devices. Text messaging is a ubiquitous form of electronic communication in modern-day society. It is frequently used to convey intimate and deeply personal information. The question in this appeal is not whether text messaging is private. Clearly, it is. The police cannot intercept text messages without obtaining a judicial authorization under Part 6 of the Criminal Code. A production order is necessary to obtain disclosure of text message conversations held by a service provider, see the Queen and Jones, and the police require lawful authority to access text message conversations stored on a personal device. In each of these contexts, the police are governed by the constitutional protections of Section 8 of the Charter. This appeal is about standing. In particular, it asks whether an accused is standing to challenge the search and seizure of text message conversations stored on another person's cell phone. The fact that text message conversations are private in nature, such that their inspection by the police will constitute a search under Section 8, does not mean that anyone has standing to challenge that search. Section 8 is a personal right. To bring a Section 8 challenge, an accused must show that his or her personal privacy right under Section 8 has been violated. More precisely, an accused must show that he or she had a reasonable expectation of personal privacy in the subject matter of the search. In this case, the subject matter of the search is the text message conversations between the appellant, Marakah, and his associate, Andrew Winchester. The two men exchanged a number of text messages pertaining to the illicit purchase and sale of firearms. They were both arrested, and in the process, the police seized their cell phones. A record of their text message conversations was later recovered from each of their phones. Mr. Marakah brought a Section 8 challenge against the search of his phone and the search of Mr. Winchester's phone. Justice Patillo, the pretrial application judge, found that the search of Mr. Marakah's phone was unreasonable, and he excluded the evidence obtained from it under Section 24(2) of the Charter. As for the search of Mr. Winchester's phone, while the application judge concluded that the search was unreasonable under Section 8, he found that Mr. Marakah lacked standing to pursue a Section 8 challenge. Accordingly, he ruled that the text message conversations recovered from the Winchester search were admissible. At trial, the trial judge, Omara J., used this evidence against Mr. Marakah in convicting him of 2 counts of trafficking in firearms, conspiracy to traffic in firearms, possession of a loaded, restricted firearm, and possession of a firearm without a valid license. 2 further counts of conspiracy to traffic in firearms were conditionally stayed. Mr. Marakah was sentenced to imprisonment for 9 years, less credit for pre-sentence custody. Mr. Marakah appealed from his convictions, arguing that the application judge erred in holding that he lacked standing to challenge the Winchester search and in refusing to exclude the evidence obtained from that search under 24(2). Writing for a majority of the Court of Appeal for Ontario, McPherson J.A. agreed with the application judge on the issue of standing. In dissent, Laforme J.A. concluded that Mr. Marakah had standing to challenge the Winchester search. He accepted the application judge's findings that the Winchester search was unreasonable and determined that the evidence obtained from it, which was used to implicate Mr. Marakah in the various firearms offense, should be excluded. For reasons that follow, I agree with both the application judge and the majority of the Court of Appeal that, in the circumstances, Mr. Marakah lacked the standing to challenge the Winchester search. Both legal and policy considerations lead me to this conclusion. From a legal standpoint, the reasonableness of a person's expectation of privacy depend on the nature and the strength of that person's connection to the subject matter of the search. This connection must be examined by looking at the totality of the circumstances in a particular case. Control over the subject matter and the circumstances is a crucial factor in assessing an individual's personal connection to it. Where an individual lacks any measure of control, this serves as a compelling indicator that an expectation of personal privacy is unreasonable, and that the individual does not have standing to challenge that search. Here, Mr. Marakah had no control whatsoever over the text message conversations on Mr. Winchester's phone. Mr. Winchester had complete autonomy over those conversations. He was free to disclose them to anyone he wished, at any time, for any purpose. To say that Mr. Marakah had a reasonable expectation of personal privacy in the text message conversations, despite his total lack of control over them, severs the interconnected relationship between privacy and control that has long formed part of our Section 8 jurisprudence. It is equally at odds with the fundamental principle that individuals can and will share information as they see fit in a free and democratic society. From the standpoint of policy, granting Mr. Marakah standing in these circumstances would vastly expand the scope of persons who can bring Section 8 challenges. The Chief Justice, speaking for a majority of the court, adopts an approach to Section 8 that has no ascertainable bounds and threatens a sweeping expansion of Section 8 standing. This carries with it a host of foreseeable consequences that will add to the complexity and length of criminal trial proceedings and place even greater strains on a criminal justice system that is already overburdened. Worse yet, expanding the scope of persons who can bring a Section 8 challenge risks disrupting the delicate balance that Section 8 strives to achieve between privacy and law enforcement interests, particularly in respect of offenses that target the most vulnerable members of our society, including children, the elderly, and people with mental disabilities. In my view, the logic of the Chief Justice's approach leads inexorably to the conclusion that a sexual predator who sends sexually explicit text messages to a child, or an abusive partner who sends threatening text messages to his or her spouse, has a reasonable expectation of privacy in those messages on that child or spouse's phone. With respect, I cannot accept this result. I would dismiss the appeal and uphold Mr. Marakah's convictions. Part 2. A. The issue in this case is standing. 1. Introduction. A person who seeks to challenge police conduct under Section 8 of the Charter must establish the existence of a reasonable expectation of privacy in the subject matter of the alleged police search. To meet this requirement, the person must show that he or she had a subjective expectation of privacy in the subject matter and that this expectation was objectively reasonable in the circumstances. See the Queen and Spencer, the Queen and Cole, and the Queen and Tesling. This case turns on the latter of these two requirements, namely, whether Mr. Marakah had an objectively reasonable expectation of privacy in the text message conversations between him and Mr. Winchester. I hasten to point out that the issue in this appeal is not whether a text message conversation can ever attract a reasonable expectation of privacy. Clearly it can. Both police interception of text message conversations and police inspection of a private record of text messages amount to a search under Section 8 of the Charter, and the police require lawful authority to conduct them. See the Queen and Pharaon, and the Queen and Telecommunications Co. To be clear, the issue in this appeal is whether Mr. Marakah has standing to challenge the search of text message conversation on Mr. Winchester's phone. In that regard, while the subject matter of a police search may be private in nature, it does not follow that an individual with any connection to that subject matter has standing to challenge the search. See the Queen and Pugliese? Rather, as I will explain, in assessing whether a person can assert a reasonable expectation of personal privacy over the subject matter of the search, the nature and strength of the person's connection to the subject matter must be examined with an eye to the specific circumstances of each case. 2. The inquiries addressed by the reasonable expectation of privacy test. The existence of a reasonable expectation of privacy has generally been framed as a single issue. However, the determination of whether there is a reasonable expectation of privacy addresses two distinct inquiries. 1. Whether the police activity in question amounts to a search or seizure, such that Section 8 of the Charter is triggered, a search inquiry, and 2. Whether an individual has standing to challenge a particular search, standing inquiry. Each inquiry fulfills a distinct purpose in the Section 8 analysis. The search inquiry is objective in nature. It asks whether the subject matter of the alleged police search is private in nature, and such that someone may, in the circumstances, hold a reasonable expectation of privacy in it. See the Queen in Wong, the Queen in Buhay, the Queen in Plant, and the Queen in Ward. In the present case, no issue is taken with the fact that the Winchester search amounted to a search or seizure within the scope of Section 8. The text message conversations are objectively private in nature and constitutionally protected by Section 8. They may, and often will, contain intimate and deeply personal information that is central to one's biographical core. When text message conversations are sheltered from public access on a personal phone, there is no basis for arguing that they are not private in nature, such that the police would be relieved from having to comply with Section 8 of the Charter. See Feyron at paras 51 to 54. In the case where it is obvious that the police activity in question amounts to a search or seizure under Section 8 of the Charter, such as here, the real question is whether an individual claimant has standing to challenge the search. Homes, vehicles, and computers are prime examples of objectively private subject matter that fall within the protection of Section 8 of the Charter. But this does not settle the question of standing, which may entail a separate inquiry. See the Queen in Edwards. The Queen in Edwards serves as an example. In that case, the main issue facing the court was whether a boyfriend had standing to challenge a search of his girlfriend's apartment. Likewise, in the Queen in Belnevis, a passenger standing to challenge a vehicle search was an issue. In addition, in Cole, the court considered whether an employee had standing to challenge a search of his work-issued computer. Standing is premised on the notion that not everyone can challenge police conduct that amounts to a search or seizure under Section 8 of the Charter. In Edwards, this court indicated that a person must have standing to challenge a search under Section 8 because Section 8 is a personal right. It protects people, not places. In addition, a claim for relief under Section 24(2) of the Charter can only be made where a person whose charter rights have been infringed. As a result, a particular claimant will only have a right to challenge under Section 8 of the Charter where he or she can establish a reasonable expectation of personal privacy in the subject matter of the search. See Edwards at paras 45 and 51, Pugliese, the Queen in Sandu. The standing requirement under Section 8 should not be confused with the condonation or encouragement of charter breaches by the police. Irrespective of whether an individual claimant has standing, where the police conduct amounts to a search, it remains subject to Section 8 of the Charter. The denial of standing to an individual claimant does not signify a grant of immunity to the police from Section 8. Rather, the denial of standing simply means that an individual claimant is not personally entitled to advance a challenge to the reasonableness of the police search. Another claimant may have standing to bring a Section 8 challenge against the search or seizure in his or her own criminal trial. Moreover, as I will explain in due course, even where Section 8 standing is denied, Section 7 and 11D of the Charter offer residual protection that can, in certain circumstances, provide a claimant with an alternative route to challenge police conduct in the course of a search or seizure. This ensures that the effect of the standing requirement are not exploited by the police as a loophole in the Charter protection. B. Mr. Marakah lacks standing. 1. The subject matter in this case. The first step in determining whether Mr. Marakah has standing is to define the subject matter of the police search. This must be done with a careful eye to the privacy interests at stake in the subject matter. In this case, private conversations that could reveal intimate information about the participants. See Ward at para 65, Spencer at para 26. The Chief Justice defines the subject matter of the search as an electronic conversation. I take no issue with that characterization. The text message conversations between Mr. Marakah and Mr. Winchester were what the police were really after when they searched Mr. Winchester's phone. See Ward at para 76. Accordingly, and consistent with the Chief Justice's characterization, I would define the subject matter of the search as text message conversations between Mr. Marakah and Mr. Winchester. 2. The objective reasonableness of Mr. Marakah's expectation of privacy. Once it is understood that the subject matter of the search in this case is the text message conversations between Mr. Marakah and Mr. Winchester, the question then becomes whether Mr. Marakah had a reasonable expectation of personal privacy in those conversations. In my respectful view, he did not. This is borne out by both legal and policy considerations. From a legal standpoint, assessing the reasonableness of an individual's expectation of personal privacy requires examining the nature and strength of the individual's personal connection to the subject matter of the search. Control over the subject matter and the circumstances of the case is a crucial factor in evaluating the strength of an individual's connection to it. Absent exceptional circumstances, a reasonable expectation of personal privacy requires some measure of control over the subject matter of the search. In this case, Mr. Marakah had none. Granting him standing in these circumstances is unprecedented and severs the interconnected relationship between privacy and control that has formed a part of our Section 8 jurisprudence. Furthermore, granting Mr. Marakah standing endorses as reasonable an expectation of privacy that is at odds with the fundamental principle that individuals can and will share information as they see fit in a free and democratic society. From the standpoint of policy, the Chief Justice's approach vastly expands the scope of persons who can bring a Section 8 challenge. This expansion carries with it a host of practical implications which will add to the burdens of an already overburdened criminal justice system and risk disrupting the delicate balance that Section 8 strives to achieve between privacy and law enforcement interests. A. The reasonable expectation of privacy test is context-driven. The reasonable expectation of privacy test requires looking at the totality of the circumstances in any given case. Put another way, the reasonable expectation of privacy test is context-driven. See Edwards at para 45, Spencer at para 17, Cole at para 52. The reasonableness of an accused's expectation of personal privacy depends on the nature and strength of his or her connection to the subject matter of the search and the circumstances of the case. The nature and strength of this connection will vary depending on context. As such, an accused may have a reasonable expectation of personal privacy in the subject matter of a search in one context, but not in another. Countless examples illustrate this point. For instance, DNA is capable of revealing intimate details about people that are central to their biographical cores. Nonetheless, the reasonableness of an expectation of personal privacy in DNA may, and often will, vary depending on the context. While an accused may reasonably expect informational privacy in DNA when it is found on his body or stored at a hospital, the same cannot be said when the same DNA is deposited on a complainant or a physical object at a crime scene in a public place. See the Queen and Stillman. Similarly, a person may have a reasonable expectation of personal privacy in his or her intimate thoughts about friends, hobbies, and romantic interests when they are recorded in a diary, but not when these same thoughts are shared publicly on social media or reality television. Finally, a person may have a reasonable expectation of personal privacy in the informational contents of a garbage bag when it is inside his or her home, but not when the same garbage bag is placed on the curb outside of the home for collection. See Patrick at para 64. In sum, an individual may have a reasonable expectation of personal privacy in the subject matter in one context, but not in another. Although the subject matter itself remains the same, the nature and strength of a person's connection to the subject matter will vary depending on the circumstances. Context is therefore necessary for determining whether a person has standing to challenge a search under Section 8 of the Charter. And, as I will explain, when it comes to the reasonableness of a person's expectation of privacy in a communication, including text message conversations, control is a crucial contextual factor. B. The relationship between control and privacy. Control is inseparable from the concept of privacy. As stated by Doherty and J.A. in The Queen and Belneves, control of access is central to the privacy concept. A total absence of control is therefore a compelling indicator that there is no reasonable expectation of personal privacy. At the same time, control must not be equated with ownership and does not necessarily require formal property rights. See Pugliese at pages 265 to 67, Cole at para 51. Rather, control has a nuanced and functional meaning in this context. Direct or exclusive control is not necessarily required. Control distinguishes a personal desire for privacy from a reasonable expectation of privacy. In a perfect world, one might desire privacy rights over the use of any and all personal information that could potentially expose, embarrass, or incriminate oneself. However, Section 8 of the Charter protects only a reasonable expectation of privacy. A desire to protect a certain subject matter that has the capacity to reveal intimate information may be useful in identifying whether a subjective expectation of privacy exists, but control is a crucial part of what makes that expectation of privacy objectively reasonable. In saying this, I do not mean to downplay the faith and trust that people place in others to maintain confidence and keep sensitive information to themselves. Depending on the nature of the relationship, a person may well have a subjective expectation of privacy in communications sent to another. For example, husbands and wives, and parents and children, may subjectively expect that their communications will not be betrayed, although this will not always be the case. The same can be said about good friends and associates. But we are not here concerned solely with a person's subjective expectation of privacy. We are dealing with the legal requirements of Section 8 of the Charter and the balance it is meant to achieve between the privacy rights of individuals and the public interest in law enforcement. This requires that a person's subjective expectation of privacy be objectively reasonable as well. When assessing the objective reasonableness of a claimant's expectation of personal privacy in the subject matter of a search, the claimant's control over the subject matter is vital. The standing inquiry is concerned with a claimant's personal connection to the subject matter and the circumstances of the case. Control plays an integral role in defining the strength of that connection. The importance of control is illustrated in Section 8 cases where standing has been the key issue. For instance, in Edwards, there was no question that the intrusion by the police into the apartment occupied by the claimant's girlfriend amounted to a search under Section 8. The sole issue was standing, whether the claimant himself had a reasonable expectation of personal privacy. In concluding that Mr. Edwards lacked standing, the court focused on factors which related to his degree of control over the apartment, that Mr. Edwards was just a visitor, he did not contribute to the rent or household expenses, and he lacked the authority to regulate access to the premises. The court summed up its rationale for denying standing as follows. An important aspect of privacy is the ability to exclude others from the premises. This is apparent from one of the definitions of the word privacy found in the Oxford English Dictionary. It is set out in these terms: b. The state or condition of being alone, undisturbed, or free from public attention, as a matter of choice or right, freedom from interference or intrusion. The right to be free from intrusion or interference is a key element of privacy. It follows that the fact that the appellant could not be free from intrusion or interference in Miss Evers' apartment is a very important factor in confirming the finding that he did not have a reasonable expectation of privacy. Similarly, in Belnevis, the main issue is whether a passenger, Miss Lawrence, had a reasonable expectation of personal privacy in the vehicle she was in when it was stopped by the police. In concluding that Miss Lawrence, unlike the driver, lacked standing to challenge the search, the court highlighted the absence of control as the key factor. There was no evidence that she had any control over the vehicle, nor that she had used it in the past or had any relationship with the owner or driver which would establish some special access to or privilege in regard to the vehicle. Lawrence did not demonstrate any ability to regulate access to the vehicle. Granted, these cases were concerned with territorial privacy in homes and vehicles. However, control remains equally important in respect of informational privacy. See Spencer at para 40, Ward at para 60. Control is integral because of the ease with which information can change from private to public in nature, depending on the context. In this regard, privacy has been defined as the right of the individual to determine for himself when, how, and to what extent he will release personal information about himself. See the Queen and Duart. See also A.F. Weston, Privacy and Freedom, cited in Tesling. See also Spencer at para 40. For private communications in particular, the concept of control helps to explain why a claimant may have a reasonable expectation of personal privacy in a communication while it is ongoing, but not in the same communication once it has been received. The ability of an individual to control the circumstances in which something is said is central to the existence of a reasonable expectation of personal privacy in the communicative process. See Duart at page 51. In choosing who to speak it, where the conversation takes place, and the medium of communication, the individual exercises control over the ongoing conversation such that he or she may reasonably expect the conversation to be private. That said, absolute control is not guaranteed. During a conversation, there is always a risk, however remote, that someone may be listening in and making a permanent record of the conversation. But this risk is not one that the individual should reasonably be required to bear. See Duart at pages 48 and 49. This court has held that people should not have to assume, as the price of choosing to speak to another human being, the risk that every time they speak, someone, be it the state or some other third party, may be recording their words. If every time people open their mouths they had to assume the risk that someone might be recording their words, it would never be reasonable to expect privacy in an ongoing conversation. As this court noted in Duarte, a society in which individuals must bear this risk would be one in which privacy no longer had any meaning. Hence, if the police were to intercept a text message conversation while it was ongoing, the sender would have standing to challenge the search under Section 8 of the Charter. See the Queen in Chayeta, the Queen in Rendon, R.W. Hubbard, P.M. Browdy, and S.K. Fenton in Wiretapping and Other Electronic Surveillance, Law and Procedure. By contrast, once a private communication is received, an individual generally retains no control over what another participant in the conversation will do with his or her record or recollection of it. In the case of an oral conversation, once the conversation is over, each participant is left with an independent recollection of it. This recollection falls within his or her exclusive control, and he or she is free to share with anyone, at any time, and for any purpose. Similarly, in the case of a text message conversation, once a text message is received, both sender and recipient are left with an independent record of the conversation. They each have exclusive control over their own record and can freely share it with anyone and everyone. In both scenarios, there is a complete lack of control over the other person's record or recollection of the conversation. Accessing a text message conversation on a recipient's phone therefore occurs in a different context from that of an interception, one in which the sender no longer has control over the subject matter of the search. This is a compelling indicator that he or she no longer maintains a reasonable expectation of personal privacy in that conversation. The risk that a recipient may repeat what is said during a conversation or share his or her record of the conversation with others is the risk that individuals must reasonably assume, and thus may defeat a reasonable expectation of privacy. See Duarte at page 49. As I explained below at paras 173 to 177, a person's expectation of privacy in an informational subject matter that falls under another person's exclusive control cannot be reasonable in a society that values the freedoms of individuals to share information. That said, control is not the exclusive consideration that informs the existence of a reasonable expectation of personal privacy, and there are exceptional cases where control is not necessary. Where a loss of control over the subject matter is involuntary, such as where a person is in police custody or the subject matter is stolen from the person by a third party, then a reasonable expectation of personal privacy may persist. See Stillman at paras 61 to 62. Privacy may persist in a tissue discarded while in police custody. See the Queen in Law. Privacy may persist in a safe stolen by a third party. In general, however, recognizing a reasonable expectation of privacy in the face of total absence of control is, in my view, both unprecedented and antithetical to the notion of personal privacy. Some measure of control is therefore generally necessary to establish standing. In saying this, I wish to be clear that control does not necessarily need to be exclusive or direct. Other degrees or forms of control can give rise to a reasonable expectation of personal privacy. Non-exclusive control. Control does not need to be exclusive. For example, in Cole, this court considered whether a teacher had a reasonable expectation of personal privacy in the information content of his school-issued computer, over which he did not have exclusive control. The school owned the computer and retained the right to monitor its use at any point in time. In assessing whether Mr. Cole had a reasonable expectation of personal privacy, the court concluded that his lack of exclusive control diminished his privacy interest in his laptop, at least in comparison to the personal computer at issue, but did not eliminate it entirely. That is consistent with this court's prior conclusion that a reasonable expectation of privacy may exist in a hotel room, even when an individual is aware that hotel staff or other guests will have access. In short, while a lack of exclusive control may diminish the strength of a reasonable expectation of privacy, it does not necessarily eliminate it. See Cole at para 58, the Queen and Gombach at para 41. But, and this is critical, the absence of exclusive control is not the same thing as a total absence of control. In Cole, for example, Mr. Cole had possession of the computer, the ability to exclude persons other than his employer, and control over its informational content, as he was able to browse the internet and store personal information on the hard drive. Crucially, he retained the ability to delete information on the computer and prevent its dissemination. Thus, it was possible for him to maintain a reasonable expectation of personal privacy in the subject matter. Likewise, in Wong, although a number of individuals had access to the hotel room, Mr. Wong retained the ability to regulate that access by excluding certain individuals. Shared or qualified control is still a form of control that may ground a reasonable expectation of personal privacy. If, for example, Mr. Marakah and Mr. Winchester shared control over Mr. Winchester's phone, then this would change the Section 8 analysis. The same can be said if Mr. Marakah could remotely access the text message conversations on Mr. Winchester's phone. In both scenarios, Mr. Marakah would have shared control over the text message conversations on Mr. Winchester's phone, and his expectation of personal privacy in those conversations would in all likelihood be reasonable. But that is not the case here. Indeed, Mr. Marakah repeatedly asked Mr. Winchester to delete the text messages from his phone, further evidence that Mr. Marakah had no control over the text message conversation on Mr. Winchester's phone. The situations in Cole and Wong therefore differ markedly from the present case. 2. Constructive control. In addition, control need not always be direct. A reasonable expectation of privacy will likely arise where a claimant exercised personal control over the subject matter in issue, as in the case of one's home, possessions, and body. However, under a functional approach, constructive control may suffice to ground a reasonable expectation of personal privacy in other contexts. For example, constructive control may exist by virtue of a claimant's professional or commercial relationship with another person or entity that has a direct control over the subject matter in question. See Diamond at page 432, Spencer at paragraph 61 to 63, Plant at 294, Patrick at para 67. The most obvious examples where this arises include a claimant's relationship with a lawyer, doctor, psychiatrist, or another professional who owes a duty of confidentiality or trust to the claimant. This list is not closed, nor is it limited to formal, trust-like, confidential, or therapeutic relationships. See the Queen and Quinsnell. Accordingly, complainants may maintain a reasonable expectation of privacy in personal information contained in records held by the police, so as to trigger the third-party records production regime in Section 278.1 to 278.91 of the Criminal Code. Care must be taken in making this comparison because of the different dynamics which are in play under the Section 8 of the Charter and those that exist in a production regime. See Quinsell at paras 28 and 35 to 36. Nonetheless, due to the professional status of the police, Quinsell clarifies that the subjects of police occurrence reports could reasonably expect the police to safeguard their private information, unless and until disclosure is justified. The court explained the rationale for this at paras 39 and 43. Where an individual voluntarily discloses sensitive information to the police, or where police uncover such information in the course of an investigation, it is reasonable to expect that the information will be used for the purpose for which it was obtained, the investigation and the prosecution of a particular crime. People provide information to police in order to protect themselves and others. They are entitled to do so with confidence that the police will only disclose it for good reason. The fact that the information is in the hands of the police should not nullify their interest in keeping that information private from other individuals. This conclusion was based on the fact that the police, as professionals, are constrained in their ability to share and use information, a constraint that generally holds true for professionals who collect personal information for a specific purpose. See Diamond at pages 432 and 434 to 35, Law at paras 22 to 23 and 28. Similarly, an individual can maintain a reasonable expectation of privacy in personal information stored with certain commercial entities, such as telecommunication providers. See Jones at 38 to 46, Telus at para 32, Spencer at para 66, the Queen and Rogers Communications Partnership. These commercial entities are subject to the Personal Information Protection and Electronic Documents Act. As Cromwell J. explained in Spencer at para 63, PIPEDA permits disclosure only if a request is made by a government institution with lawful authority to request the disclosure. It is reasonable to expect that an organization bound by PIPEDA will respect its statutory obligations with respect to personal information. As these cases illustrate, even a qualified obligation on professional and commercial entities to maintain confidentiality over personal information provides a measure of constructive control which can support a reasonable expectation of privacy. This stands in stark contrast to the unfettered discretion individuals have to share information for any reason or purpose. At a normative level, the existence of a reasonable expectation of privacy in the context of professional or commercial relationships therefore does not create the same tension with autonomy interests, which may arise in the context of ordinary interactions between private citizens. See below at pairs 173 to 77. Ultimately, as this court stated in Quinsnell at para 38, whether a person is entitled to expect that their information will be kept private is a contextual inquiry. In my view, where the information in question is under the exclusive control of another person, an interest in the subject matter and a personal relationship with that person does not suffice. Something more is necessary, such as a relationship connoting some measure of constructive control or obligation, to surpass a mere hope or desire for privacy and ground a reasonable expectation of personal privacy. In sum, control, like privacy, is not an all-or-nothing concept. See Quinsnell at pairs 29 and 37. The degree and form of control that a claimant has over the subject matter of the search and the circumstances of the case is central to whether the claimant has a reasonable expectation of personal privacy. Accordingly, a total absence of any measure of control provides a compelling base to deny standing. C. Mr. Marakah had no control over the text message conversations on Mr. Winchester's phone. The text message conversations between Mr. Marakah and Mr. Winchester were accessed by police after they had been received on Mr. Winchester's phone. The conversations were not intercepted by the police during the transmission process, and they were not accessed on Mr. Marakah's phone. As I will explain, these are important contextual distinctions that show that Mr. Marakah had no control over the subject matter of the search and the circumstances of this case. In this case, Mr. Winchester had exclusive control over the text message conversations accessed by the police. The conversations were stored on his phone, and he had complete autonomy to disclose them to anyone, at any time, and for any purpose. Mr. Marakah had no control over the text message conversations on Mr. Winchester's phone, a compelling indicator that he did not have a reasonable expectation of personal privacy in them. This case is thus distinct from an interception case. It is beyond question that Mr. Marakah had a reasonable expectation of personal privacy in the text message conversations while they were in the process of transmission to Mr. Winchester's phone. In that context, Mr. Marakah had control over the circumstances in which he was communicating with Mr. Winchester. He reasonably assumed that, in conversing with Mr. Winchester through text messaging, he was communicating only to Mr. Winchester. In these circumstances, it was reasonable for him to expect that his text message conversations with Mr. Winchester would not be clandestinely intercepted. As indicated, if the police had intercepted the conversations at that stage, Mr. Marakah would have standing to challenge the search of Mr. Winchester's phone under Section 8 of the Charter. This case is also distinct from one involving police access to text message conversations on Mr. Marakah's phone. Unquestionably, Mr. Marakah had a reasonable expectation of personal privacy in the text message conversations on his own personal phone. This is because Mr. Marakah retained control over the conversations. He was able to delete them or disclose them to anyone he wished. The text message conversations on Mr. Winchester's phone are contextually different from the same text message conversations on Mr. Marakah's personal phone, just as DNA found on a complainant is contextually different from the same DNA found on an accused person's body, even though both sources may reveal identical and extremely intimate information. In sum, viewed contextually, Mr. Marakah had no measure of control over the text message conversations in the circumstances of this case. 3. The Chief Justice's approach to the reasonableness of Mr. Marakah's expectation of privacy. A. The places of the search and Mr. Marakah's control over the text message conversations. The Chief Justice asserts that the search may have occurred in one of two places. Either the police access the text message conversations in what she calls a metaphorical chat room, or they access them on Mr. Winchester's phone. Ultimately, the Chief Justice leaves unanswered the question of where the search occurred. According to her, neither the metaphorical chat room nor Mr. Winchester's physical phone exclude a reasonable expectation of privacy. In either scenario, Mr. Marakah did not give up control over the information he sent to Mr. Winchester. Rather, the two shared control over their text message conversations. With respect, the Chief Justice's approach gives rise to serious difficulties, and I cannot agree with it. I begin with the Chief Justice's first proposition, that the place of the search may be a metaphorical chat room. In her view, this electronic world of digital communication is every bit as real as a physical space. This position was not advanced by any of the parties, and the Chief Justice cites no authority for it. In my view, it is a fiction which has the effect of circumventing the overriding problem standing in the way of Mr. Marakah's bid for standing, namely, that once his messages were received by Mr. Winchester, he retained no control over them whatsoever. By evaluating the reasonableness of an expectation of personal privacy in a context that is divorced from the reality of where such a search actually occurred, in this case, Mr. Winchester's phone, the Chief Justice effectively holds that participants in a communication maintain a reasonable expectation of personal privacy in a text message conversation, regardless of where the conversation is accessed in the real world. This cannot be right. The reasonable expectation of privacy analysis is context-driven and requires looking at the totality of the circumstances, which includes the actual place of the search. The Chief Justice also proposes that the place of the search may be the physical location where the text message conversations were accessed or stored, in other words, Mr. Winchester's phone. According to the Chief Justice, in this alternative situation, Mr. Marakah's expectation of privacy is reduced, but not defeated. The Chief Justice relies on Cole to support her position that even though Mr. Marakah did not control Mr. Winchester's phone, he nevertheless shared control over the text message conversations and retained a reasonable expectation of privacy in those conversations. In my view, Cole does not support her conclusion. The Chief Justice likens Mr. Marakah's shared control over the text message conversations with Mr. Winchester to Mr. Cole's shared control over his work-issued laptop with his employer. Her analogy appears to rest on two premises. First, Mr. Marakah, like Mr. Cole, did not have exclusive control over the subject of the search. Mr. Cole's employer had access to the contents of the laptop, just as Mr. Winchester had access to the text message conversations. And second, Mr. Marakah's lack of control over Mr. Winchester's phone is irrelevant, just as Mr. Cole's lack of control over the laptop was irrelevant, because both Mr. Cole and Mr. Marakah exercised control over the information reflected therein. In this case, the text message conversations, in Cole, the pornographic images. Respectfully, I cannot agree with either premises. In Cole, the pornographic images were located on a laptop in Mr. Cole's possession, and Mr. Cole's employer was able to remotely access those images. In this case, however, the text message conversations were on Mr. Winchester's phone in Mr. Winchester's possession, and Mr. Marakah could not remotely access these conversations. As such, Mr. Marakah had no control over the conversation on Mr. Winchester's phone. The Chief Justice's second premises, that it does not matter whether Mr. Marakah had control over Mr. Winchester's phone, escapes me. If Mr. Marakah shared control over Mr. Winchester's phone, or if Mr. Marakah was able to remotely access the text message conversation on Mr. Winchester's phone, he could have deleted the text message conversations or prevented their dissemination. The ability to delete or prevent dissemination of text message conversations are telltale signs that an individual exercises control over those conversations, a compelling indicator of a reasonable expectation of privacy. Conversely, as I explain in paras 134-35, the fact that Mr. Marakah had absolutely no ability to delete or prevent dissemination of the text message conversation on Mr. Winchester's phone showed that Mr. Marakah had no control over the subject matter of the search in these circumstances. As indicated, the Chief Justice does not decide where the police accessed the text message conversations. She nevertheless points out that Mr. Marakah's expectation of privacy would be stronger if the place of the search was the metaphorical chat room than if the place of the search was Mr. Winchester's phone. The Chief Justice's either-or approach is not only confusing, it also has serious implications for the Section 24-2 analysis. The Chief Justice appears to acknowledge at paragraph 68 of her reasons that a diminished expectation of privacy lessens the impact of a charter-infringing search on a claimant's Section 8 rights, which favors admission under the second grant factor. See Cole at paragraph 92, the Queen and Grant at paragraph 76-78. In cases involving text message conversations, the third grant factor will favor admission as well, as the communication will almost always be reliable. See Grant at paragraph 81. Consequently, the charter-infringing conduct would have to be very serious under the first grant factor to justify exclusion. See Grant at paragraph 74. Indeed, it would be likely to amount to a deliberate or serious misconduct by the police. Otherwise, the attenuated impact of the breach and society's interest in adjudication on the merits are likely to tilt the balance towards admission. See Grant at paragraphs 85-86. However, by not identifying the actual place of the search, the Chief Justice equivocates on the strength of a claimant's expectation of privacy. As such, one is left to ask how courts are to engage in the difficult balancing of the three grant factors, with a view to determining whether unconstitutionally obtained electronic communications should be excluded under Section 24(2). B. Duarte does not support the Chief Justice's position. The Chief Justice relies on Duarte to say that Mr. Marakah's inability to control what Mr. Winchester did with the conversation on his phone is irrelevant to whether Mr. Marakah had a reasonable expectation of privacy in those conversations. In the Chief Justice's view, the fact that a person has assumed the risk that the recipient may share the communication with the police is irrelevant to the reasonable expectation of privacy inquiry. This is because even though a participant to a conversation may share a record of the conversation with others, it is still reasonable to expect that the state will not gain access to this record. In the Chief Justice's view, the question of whether there is a reasonable expectation of privacy is answered in relation to the state in isolation, not against the public at large. As such, Mr. Marakah's complete lack of control over the text message conversation on Mr. Winchester's phone, which Mr. Winchester can freely share with anyone, does not defeat the reasonableness of Mr. Marakah's expectation of personal privacy in those conversations against the state. In support of her position, the Chief Justice relies on a single passage from Duarte at page 44. The regulation of electronic surveillance protects us from a risk of a different order, i.e., not the risk that someone will repeat our words, but the much more insidious danger inherent in allowing the state, in its unfettered discretion, to record and transmit our words. I cannot accept this interpretation of Duarte. Like all charter rights, Section 8 provides protection to individuals against the state. State conduct is therefore required to engage Section 8. Nonetheless, in this court's significant body of Section 8 jurisprudence, including Duarte, the question of whether an individual holds a reasonable expectation of privacy in a particular subject matter is answered in relation to the world at large, not to the state in isolation. If an expectation of personal privacy is unreasonable against the public, then it is also unreasonable against the state. It is unreasonable for a person to expect publicly accessible information or other subject matter to remain private against the state in isolation. In Patrick, in finding that the accused did not have a reasonable expectation of privacy in the subject matter of the search, the court relied heavily on the fact that the garbage bags were accessible to street people, bottle pickers, urban foragers, nosy neighbors, and mischievous children, not to mention dogs and assorted wildlife, as well as to the garbage collectors and the police. No distinction was made between the public access and the state access for the purpose of the reasonable expectation of privacy analysis. If the public could access a garbage bag containing personal information left at the curb, so too could the police. In my view, when an individual assumes the risk of public access, they are equally assuming the risk of state access. This is why the risk of publicity has featured prominently in so many of this court's decisions applying to the reasonable expectation of privacy test. See Patrick at paras 2 and 43, Gombach at paras 33 and 41, Tesling at paras 40 and 46 to 47, Plant at pages 294 to 95, and Stillman at paras 62. Translated into the circumstances of this case, if Mr. Marakah assumed the risk of Mr. Winchester allowing the public to access his text message conversations, a point which the Chief Justice appears to concede at para 41, then he assumed the risk of the police accessing it. The risks of state access and public access are not distinct for the purposes of the reasonable expectation of privacy test. With respect, when the passage from Duarte that the Chief cites above is read in context, it is apparent that the court is drawing an entirely different distinction from the one that she identifies. In Duarte, the court considered whether someone could hold a reasonable expectation of privacy in an ongoing conversation, despite the risk that each participant could freely share what was said after it was complete. The court distinguished the risk that someone will repeat the contents of the private communication after it is over, from the risk that the private communication will be intercepted. The risk that a participant in a conversation will repeat the contents of a conversation after it is complete does not diminish the reasonableness of an expectation of personal privacy in the conversation while it is ongoing. Put simply, despite the reality that someone may share information from a conversation after it is complete, it is still reasonable for people to expect that their private conversations will not be covertly intercepted and recorded. In my view, this is evident from the other excerpts from Duarte where these distinct risks are discussed without reference to the state. The rationale for regulating the power of the state to record communication that their originator expects will not be intercepted by anyone other than the person intended by the originator to receive it, has nothing to do with protecting individuals from the threat that their interlocutors will divulge communications that are meant to be private. I am unable to see any similarity between the risk that someone will listen to one's words with the intention of repeating them and the risk involved when someone listens to them while simultaneously making a permanent electronic record of them. The law recognizes that we inherently have to bear the risk of the tattletale, but draws the line at concluding that we must also bear, as the price of choosing to speak to another human being, the risk of having a permanent electronic record made of our words. It is helpful to recall that Duarte was concerned with whether an interception of a private communication amounted to a search under Section 8 of the Charter. In this context, it makes sense to consider the intrusive effects of state surveillance on the communicative process. That does not mean that a person's reasonable expectation of personal privacy against the state is distinct from his or her reasonable expectation of personal privacy against the world. In sum, far from supporting the Chief Justice's view, Duarte in fact undercuts it. Duarte draws a critical distinction between the context of an interception during the communicative process and subsequent access to a recollection of a communication. In doing so, Duarte illustrates the idea that reasonableness of an expectation of personal privacy will vary depending on the context. Duarte stands for the proposition that it is reasonable for people to go about their business and carry out their daily activities in the expectation that their private conversations will not be clandestinely intercepted and recorded. That is because, in this situation, an individual has control over the circumstances in which something is said, including the medium of the communication and who it is said to. That is a far cry from the case like the present one. Here, there was no covert intrusion on the communicative process, and both parties were completely aware that in texting each other, they were creating independent records of their conversation that would fall within the exclusive control of the other. Duarte therefore provides no support for Mr. Marakah's standing claim. If anything, the reasoning in Duarte implicitly suggests that no reasonable expectation of privacy exists in a record of a private communication that falls under the exclusive control of another participant and may be freely shared with others. Indeed, the court was unequivocal that individuals inherently have to bear the risk of the tattletale. See Duarte at page 48. C. The Chief Justice attempts to limit her analysis to the facts of this case. The Chief Justice attempts to confine her analysis to the particular circumstances of this case, noting that different facts may well lead to a different result. In other words, finding a reasonable expectation of privacy in this case does not mean that a text message conversation will always attract a reasonable expectation of privacy. With respect, the Chief Justice purports to limit her analysis to the facts of this case in a way that is difficult to comprehend. If by texting each other, Mr. Marakah and Mr. Winchester created a metaphorical chat room over which they shared control, I fail to see how the same would not be true for any participant in a text message conversation. Similarly, if Mr. Marakah does exercise control over the text message conversations on Mr. Winchester's phone, it seems to me that any person who sends a text message will retain control over the conversation on the recipient's phone. In my view, contrary to what the Chief Justice states at paragraph 5 of her reasons, her approach does in fact lead inexorably to the conclusion that an exchange of electronic messages will always attract a reasonable expectation of privacy. In sum, as I read her reasons, the Chief Justice effectively holds that everyone has a reasonable expectation of privacy in text message conversations, even when those conversations are on another person's phone. As such, under her all-encompassing approach to standing, even a sexual predator who lures a child into committing sexual acts and then threatens to kill the child if he or she tells anyone will retain a reasonable expectation of privacy in the text message conversations on the child's phone. Likewise, an abusive ex-husband who sends harassing text messages to his ex-wife and threatens to harm her and their children if she goes to the police will retain a reasonable expectation of privacy in the text message conversation on the ex-wife's phone. With respect, these examples show that the Chief Justice's approach to standing is effectively boundless. To hold that the sexual predator and the abusive spouse retain a reasonable expectation of privacy in the text messages once they are received by their victims is remarkable. Indeed, I am hard-pressed to think of anything more unreasonable. This effectively eradicates the principle of standing and renders it all but meaningless. And it is no answer to say, as the Chief Justice does, that granting the sexual predator or the abusive spouse standing does not mean that the text messages on their victims' phones will necessarily be excluded from evidence. Rather, it simply gives them the right to challenge the admissibility of those messages. With respect, that response not only misses the point, it emphatically makes the point that on the Chief Justice's approach, the principle of standing is virtually limitless and, for all intents and purposes, it ceases to exist when two or more people converse with each other through text messaging or any other electronic medium. In short, it belies the Chief Justice's overriding position that standing is to be assessed on a case-by-case basis, having regard to the totality of the circumstances, and that Mr. Marakah's successful claim to standing is limited to the facts and the circumstances of his case. But even if I misconstrued her position on this, the Chief Justice provides no guidance as to what factors would militate against finding a reasonable expectation of privacy in electronic communication. Nor does she explain why the circumstances of this case are different than any other case where people participate in a text message conversation. Police, defense, and Crown Counsel, trial and appellate judges, and the public at large are left to guess when and under what circumstances electronic messages will not attract a reasonable expectation of privacy. With respect, that is a highly unsatisfactory state of affairs. 4. The freedom of individuals to share information over which they have exclusive control. In my view, it is unreasonable to expect another individual to maintain the privacy in text message conversations over which that individual has exclusive control. This is because, save for limited exceptions which do not apply in this case, individuals are free to share information that falls within their control as they see fit. Sharing a record of a private communication may be motivated by things as diverse as an opportunity for personal gain, a temptation to gossip, a request from a third party, or for no reason at all. At the extreme end, where a private communication takes the sinister form of death threat or sexual luring of a child, an individual's sharing may be motivated by interests as sacrosanct as an individual's personal safety, dignity, and liberty. See the Queen in Santu and the Queen in Craig. Indeed, in some cases, a private communication may involve physical violence, as in the case of a person capturing a video of verbal and physical abuse by his or her partner. It is unrealistic to say that a person will have a reasonable expectation of privacy in records of communications over which that person has no control and which are under the exclusive control of someone else. The sexual predators and abusive partners can maintain a reasonable expectation of privacy in records of communications within the exclusive control of their victims illustrates the implausibility of this proposition. Not only is this proposition implausible, it is also at odds with what this court has recognized as a hallmark of a free and democratic society, namely the freedom of individuals to share information as they wish. See Grant and Tor Star Corp., Thomson Newspaper Company, and Canada Attorney General. Section 8 protects standards of privacy that persons can expect to enjoy in a free and democratic society. See Wong at page 61. Given that our society recognizes that people may freely share information as they see fit, it is unreasonable to expect privacy in informational subject matter that falls within the exclusive control of another person. Such an expectation would run counter to what the society has deemed both valuable and fundamental, the freedom to share information. It follows that the proper approach to Section 8 is one that recognizes that, absent a relationship connoting some measure of constructive control, including a legal, professional, or commercial relationship of the kind described above, each participant in a text message conversation can choose to keep it his or her record of it private, or to share it freely with anyone or everyone, including with the police. To conclude otherwise would not only be inconsistent with the core Canadian value, it would also greatly expand Section 8's standing, with serious implications for the administration of criminal justice. 5. Practical considerations regarding law enforcement and the administration of criminal justice. A. Granting Mr. Marakah standing would burden an already overburdened criminal justice system. Since Hunter and Southam Incorporated, courts have acknowledged that the protection guaranteed under Section 8 of the Charter entails striking a balance between the privacy and law enforcement interests. An assessment must be made as to whether, in a particular situation, the public's interest in being left alone by government must give way to the government's interest in intruding on the individual's privacy in order to advance its goals, notably those of law enforcement. The need to balance societal interest in protecting individual dignity, integrity, and autonomy with effective law enforcement has been specifically identified as a key consideration in forming the reasonable expectation of privacy. See Patrick at para 20, quoting Plant at 239, see also Tesling at 17 and 18, Duart at pages 45, Diamond at page 428. In the present case, If it is determined that Mr. Marakah has a reasonable expectation of personal privacy in the text message conversations on Mr. Winchester's phone, I foresee a number of troubling consequences for law enforcement and the administration of criminal justice that could disrupt this balance. Although these consequences are not determinative of the reasonableness of Mr. Marakah's expectation of privacy, their cumulative effect weighs heavily in favor of denying him standing. Under the Chief Justice's approach, where the police search a cell phone or other device for an electronic communication, any participant to that communication would have standing to challenge the lawfulness of the search. The same may be true even where a witness voluntarily shares an electronic communication with the police, as there remains uncertainty in the law as to whether the reception by the police of this evidence amounts to a search engaging Section 8 of the Charter. See the Queen and Orlandus Hadsburgo. As such, in these circumstances, Section 8 may be engaged and a search warrant may well be necessary to comply with Section 8. Indeed, the Chief Justice appears to concede that police may require a warrant even where a victim or his or her parents voluntarily provide police with threatening or offensive text messages. The law governing third-party consent presents further difficulties. In Cole, at paras 74 to 79, this court rejected the notion that a third party could validly consent to a search or otherwise waive a constitutional protection on behalf of another. If this stands as a strict rule, then the police would never be able to obtain information about an accused through electronic communications offered by victims and witnesses on consent. Anytime this occurred, an accused person would have standing to challenge that search, and it would constitute an automatic infringement of the accused's Section 8 right. As a result, the overall number of instances where the police will be required to obtain a judicial authorization to gather evidence could increase dramatically. Even if the prohibition on third-party consent is relaxed, this would not solve the problem. The doctrine of consent still has onerous requirements which would be undoubtedly put to the test by accused persons seeking to exclude evidence provided by witnesses on consent. See the Queen and Reeves at paras 51 and 63 to 71. In the absence of a warrant, any search or seizure of this evidence by the police would be presumed to be an unreasonable search, and the Crown would bear the burden of demonstrating compliance with Section 8. See the Queen and Nolet at para 21, the Queen and Collins at pages 277 to 78. This would require the Crown to establish on a balance of probabilities that the elements of fully informed and voluntary consent were met. See the Queen and Wills, as well as the Queen and Borden. And it would not be a foregone conclusion that these requirements could always be satisfied. For example, in assessing the issue of consent, it is possible that the capacity of vulnerable complainants, including children, adults with mental disabilities, or the elderly, could be challenged, as could the validity of consent provided by a reluctant or recanting witness. Moreover, the process itself could be needlessly harmful, exposing children or other vulnerable witnesses to cross-examination about consent given to the police to search their phone or other devices for private communications that may involve threats or sexual predations. See Sandu, Lowry, and Craig. Ultimately, the resulting uncertainty is likely to cause the police to seek judicial authorizations, in most cases out of an abundance of caution, to take basic investigative steps, such as obtaining records of electronic communications between witnesses and accused persons. The increased need for these judicial authorizations could strain police and judicial resources in an already overburdened criminal justice system. Investigations would be slowed, more judicial officers would be required, and the administration of criminal justice as a whole will suffer, and the effects do not end at the investigative stage. At the trial stage, each of the above repercussions could significantly complicate and prolong proceedings. For example, in large project prosecutions, accused persons could gain standing to challenge numerous searches conducted against collateral targets that yield records of any private communications involving the accused person. See the Queen and McBride at para 2. Beyond the court time and resources required to accommodate this litigation, it could significantly expand the scope of already voluminous disclosure that would become relevant in mounting these collateral Section 8 challenges. The Chief Justice does not provide any solutions to these foreseeable consequences, stating that, if and when such concerns arise, it will be for courts to address them. But experience teaches that these concerns are real, and we ignore them at our peril. It is only prudent for this court to consider the predictable consequences of its decision in a case like the present one, which has major implications for the criminal justice system. This is especially so at a time where our criminal justice system is stressed to the breaking point. In this regard, I note that the Chief Justice's decision to leave for another day these obvious concerns departs from the approach taken in past criminal law matters, where she herself has engaged in elaborate forecasting of the doctrinal and practical implications arising from this court's decisions. See the Queen in DAI and the Queen in Hutchinson. In my view, the cumulative effect of the practical concerns for law enforcement and the administration of criminal justice weighs heavily in favor of denying standing to claimants such as Mr. Marakah. In saying this, I wish to stress that denying Mr. Marakah standing does not grant the police immunity from Section 8 of the Charter, where, as here, the police activity amounts to a search or seizure. It remains subject to Section 8, and a particular claimant's standing should not be mistaken as the exclusive means of enforcement. Another claimant may have standing to bring a Section 8 challenge against the search or seizure in his or her own criminal trial, or to bring a claim for charter damage. See Vancouver City and Ward. Moreover, I will now explain, even where Section 8 standing is denied, Section 7 and 11D of the Charter offer residual protection that can, in certain circumstances, provide a claimant with an alternative route to challenge the propriety of a police conduct in the course of a search or seizure. B. Section 7 and 11D of the Charter ensure protection against police abuse and charter evasion. Mr. Marakah suggests that denying him standing will create a gap in the protection guaranteed by Section 8 of the Charter, and police would remain free to search through the contents of a recipient's cell phone without any lawful authority whatsoever to collect evidence against the sender. AF at Paras 61. He echoes the comments of Laforme J.A. at Paras 173 to 74 of his dissenting reasons at the Court of Appeal. Increasingly, the police have access of records of electronic communications stored by third parties, and, as far as text messages are concerned, they will always have this ability since there will always be at least two parties with a copy of the message. In my view, concluding that individuals cannot challenge the search or seizure of records in their text messages will permit the Crown to routinely admit such messages into evidence even if the message were obtained in defiance of Charter-protected rights, and even if the admission of the evidence will bring the administration of justice into disrepute. This concern about the police exploitation to the effects of the standing requirement through targeted third-party devices without lawful authority is not borne out by experience. Following this court's decision in Edwards, there is no evidence of any epidemic of unlawful residential searches seeking evidence against third party. Nor is there evidence of a flood of unlawful car searches targeting passengers after this court's decision in Belnevis. As indicated, irrespective of whether a particular claimant has standing, the police remain subject to Section 8 of the Charter when they conduct a search of a home, car, or cell phone. More importantly, insofar as deliberate charter evasion is a realistic concern, it can be fully addressed under Section 7 and 11D of the Charter, which in conjunction with Section 24.1 empower a trial judge to exclude evidence as a matter of trial fairness. See the Queen and Belland. This court has previously held that even where an accused person cannot invoke the protection of a charter right under Section 8, evidence may be excluded if it is gathered in a way that fails to meet certain minimum standards. See the Queen and Hape, as well as the Queen and Harrer. This ensures that the conduct of law enforcement does not go completely unchecked, even when certain charter rights are not directly engaged. In my view, Section 7 and 11D are equally applicable in providing residual protection against any deliberate charter evasion or abuse of the limitations of Section 8 standing by the police. The discretion to exclude evidence pursuant to Sections 7, 11D, and 24.1 of the Charter to protect trial fairness is flexible and contextual. See Belland at Para 18. It may be engaged if evidence is obtained through deliberate charter evasion or serious misconduct by the police that rises to a level where trial fairness could be compromised by its admission. It may also arise from conduct and strategy deployed across related investigations and prosecutions. For example, it may be appropriate to exercise this discretion where the grounds for a search of an accused person derive from the fruits of a different search in a related investigation which the accused lacks standing to challenge. The same could be said where the police conduct a series of unlawful searches and seizures in related investigation and the Crown tenders only evidence which each accused person lacks standing to challenge. This list is not closed, and the trial judge should be trusted to exercise this discretion robustly where trial fairness is at risk. At the same time, a measure of restraint is required to ensure the purpose of Section 8 standing requirement is not rendered illusory by turning Section 7 and 11D into a surrogate for its protection. A different standard applies, and in some cases, evidence may be obtained in circumstances that would not meet the rigorous standards of the Charter, and yet, if admitted into evidence, would not result in a trial being unfair. In this regard, I believe that trial fairness concerns under Section 7 and 11D would rarely, if ever, be engaged where cases where evidence is voluntarily provided by a witness in response to an inquiry by the police. To avoid the practical concerns canvassed earlier in paras 182 to 84 of these reasons, I wish to be clear that Section 7 and 11D do not provide a vehicle for an accused person to litigate the validity of a witness consent of a search in a context where the witness is cooperating with a police investigation. In such circumstances, the prospect of admitting evidence without scrutiny for compliance with Section 8 falls well short of compromising trial fairness. In this case, the application judge found that the searches of the text message conversations stored on the phones of Mr. Marakah and Mr. Winchester both infringed Section 8 of the Charter. As neither claimant has standing to challenge the search of the other's phone, evidence of those text message conversations was admissible against both Mr. Marakah and Mr. Winchester. Although this result gives me pause, it has not been suggested that the police conduct giving rise to it was a product of design. Nor do the application judge's findings indicate that the police engaged in deliberate charter evasion or serious misconduct in the course of either search. In these circumstances, there is no basis to conclude that the fairness of Mr. Marakah's trial was tainted by the admission of the record of the conversations obtained in the Winchester search. As a result, this is not a case in which it is appropriate to exercise the residual discretion to exclude evidence under Section 7 and 11D of the Charter. 6. Conclusion on Section 8 standing. The Chief Justice's approach to the reasonable expectation of privacy analysis suffers from several shortcomings. First, she does not determine where the search actually occurred, despite maintaining that the strength of Mr. Marakah's expectation of privacy will vary depending on the place of the search. Without knowing whether the place of the search was a metaphorical chat room or Mr. Winchester's physical phone, courts have no way of knowing how to assess the strength of Mr. Marakah's expectation of privacy. This uncertainty will have serious implications when courts must assess the impact of an unlawful search on a claimant's Section 8 right for the purpose of a Section 24(2) analysis. Second, although the Chief Justice proposed to confine her finding of a reasonable expectation of privacy to the circumstances of this case, applying her framework leads to only two possible conclusions. Either all participants to text message conversations enjoy a reasonable expectation of privacy, or a criminal justice stakeholder, including trial and appellate judges, are left to decipher on a case-by-case basis, without any guidance, whether a claimant has standing to challenge the search of an electronic conversation. Third, the Chief Justice does not confront the host of foreseeable, practical problems with her approach, saddling the courts with the task of sorting them out when they inevitably arise. I take a different approach. In my view, divorcing privacy from any sense of control in the present context would distort and decontextualize the concept of privacy, create tension with the autonomy of individuals to freely share information, depart from this court's long-standing jurisprudence, and raise a host of practical concerns for law enforcement and the administration of criminal justice. Assessing the reasonableness of an expectation of personal privacy is a contextual exercise, one which requires evaluating the nature and strength of a particular claimant's connection to the subject matter of the search. In this case, Mr. Marakah had absolutely no control over the text message conversation on Mr. Winchester's phone. As such, Mr. Marakah could not reasonably expect personal privacy in those text message conversations. As a result, while accessing the text message conversations on Mr. Winchester's phone amounted to a search under Section 8, in my view, Mr. Marakah lacks standing to challenge its reasonableness under Section 8 of the Charter and seek exclusion of the evidence of his conversations with Mr. Winchester discussing the purchase and sale of firearms under Section 24(2). Part 3. Conclusion. I would dismiss the appeal and uphold Mr. Marakah's convictions.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.